Steve and Bob, thank you for insightful papers. Greg and Becky and others, thank you for this invitation to come respond, even though I'm not a lawyer. Never been to law school, not going to pretend to be a lawyer. Actually, have no desire to be a lawyer. But I did have a, you might call it a brush with the law, not in that sense, which I think does illustrate, some of the contrast between Brandeis and Holmes that Bob you're referencing. Several years ago, I spent my summer vacation as the foreman for a jury on a murder trial. And in the jury selection, there were probably 100 or so of us in the room that were being screened out. And it came to me kind of early on in the process. There were still a whole lot of people in the jury room. And the judge started asking me a series of questions. And he said, first of all, I see you're a professor. And he said, what do you teach? I said, I teach ethics. And for some reason, the whole place erupted in laughter. I'm still not quite sure I understood that. But then the judge said, I see that you teach in a religious college. And I say, yeah, that's correct. I said, and then he said, do you think you can follow the law? I thought, I'm not exactly sure where you're going with this, but I'm not sure I like it. And then he saw that puzzled look on my face, and he clarified what he meant. And he said, what I'm asking really is, do you believe that there's another law that's higher than the law of the land? I said, well, yeah, as a matter of fact, I do believe that the law of God is higher than the law of the land. I went on to say, I can't readily envision a way where those two would conflict in this case. But the fact that he even asked the question, I thought was indicative of the kind of conflict that you cited between Holmes and Brandeis, and how an indication of how Holmes has carried the day in legal circles. Now, my area is in bioethics and business ethics, and so what I'd like to do is extend the application a bit that both Bobby and Steve have laid out for the law into those fields. And even though I'm not a lawyer, I have given considerable thought to the intersection of law and public policy, particularly as it relates to bioethics. But just, I guess, a general comment first. The competing positions, Bob, I think that you cite between Brandeis and Holmes was advanced as a more formal debate, what I would call the last gasp for Louis Brandeis, in a series of papers that the Harvard Law Review published in the late 1950s as a debate between Oxford professor H.L.A. Hart and Harvard Law professor Lon Fuller. Well, Hart never denied that legal systems could be strongly influenced by morality, and that there are places where the law and morality do intersect. He, of course, denies an inherent connection between the two. That is, simply because a law contradicts standards of morality, it does not follow that the law in question is not a valid law. On the other hand, he holds just because something is morally desirable, it doesn't follow that such a rule is a valid law. For Hart, and I think for the school of legal positivism that is carried the day today, the validity of law is dependent on its having been legislated into law by a bona fide legislative body, not on its relation to any particular moral norm. Now, Fuller, I think, argued, in my view, very persuasively, that the distinction between law and morality may not be the most helpful way to frame this, but instead he proposes a distinction between order and good order that the law provides. All law produces order. Yet in his view, there's a clear difference between the order produced by the law and a good order in which individual citizens recognize that the law that provides such an order is necessary, right, and just. Now, Fuller is very clear that the legal system cannot be built on law alone. Rather, it depends on the moral attitudes that undergird it, what he calls a morality external to law. In his view, any valid law must be accepted not only as a law, but as a good and just law, and that the legal system must have what he calls an internal morality. that is, basic norms that clearly point to the source of the laws and procedures by which laws are made. I think it's Fuller's view of the law that I read as very similar to Louis Brandeis, and I think tragically a view that's being lost today as moral knowledge disappears at the institutional level. Now let me just touch briefly on my own primary field of bioethics. You might think from following that historically that this has been a field that has sort of bucked the trend of the disappearance of moral knowledge. On the surface, it would appear that way, but I think upon closer examination, not quite the case. In bioethics, the body of moral knowledge, I think, although calling it a body of moral knowledge, I think it's probably that's a bit of a stretch, but for some time, it's been the fourfold statement of principles articulated by Tom Beecham and James Childress, known for a long time as the Georgetown mantra. These four principles, as you may be aware, consist of autonomy, beneficence, non-maleficence, and justice, which looks on the surface to be a pretty solidly deontological system that gives direction to clinical ethics at the bedside, and would appear to give a challenge to the notion that moral knowledge has disappeared from bioethics. But in more than 3 decades in my own work of applying this at the bedside and watching others and reading others apply this to clinical ethics in particular, it's become apparent to me that the Georgetown mantra does not at all function like a field of moral knowledge. For example, when these principles conflict, which happens very frequently at the bedside, it is almost always the case that the principle of autonomy is the trump card that takes priority over all the others. In fact, in my view, it's very rare that physicians at the bedside will make decisions counter to the autonomy of the patient, or in the case of a child, counter to the autonomy of the parents. And I spent about 15 years consulting in several healthcare systems in the area, and we tried for years and years to get physicians to actually go against a family's wishes for inappropriate levels of aggressive treatment at the end of life, on the basis that it's morally wrong to impose burdens on patients for the benefit of their family members, which is frequently what takes place. In fact, in the hospital, we would refer to this, Aaron, you may appreciate this, as we are now treating the family when that happened. But very few physicians were willing to do that. In fact, I'm still looking for the first one in California who was willing to do that, even though since 1990, the law has protected them from liability if they procedurally did so correctly. Now, of course, it doesn't protect them from being sued. It only protects them from their opponent prevailing in a lawsuit, which I think for most physicians, being sued there's no significant difference between being sued and losing in a lawsuit. They're trying to avoid that. And in public policy and bioethics too, I would suggest a bit of an alteration, Steve, to what you had suggested about the utilitarian framework that seems to be one of the avenues for making public policy in the absence of or in the loss of moral knowledge. I would refer to this as a truncated utilitarianism that's used in most public policy areas in bioethics. But it's an extension of the primacy of autonomy that we see at the bedside. Standard utilitarian considerations include a calculus of harms and benefits both. However difficult it is to weigh those, and in my view, the harms and benefits only make sense if some value considerations are smuggled into those to explain what actually makes something harmful and beneficial. However, most public policy discussion in bioethics gives maximum space for autonomy unless there are compelling, tangible, measurable harms that come from that exercise of freedom. I think the debate over the legality of assisted suicide is a good example of this. The principled aspects of the debate, not taking innocent life, not licensing physicians to kill their patients, etc., are being subsumed by the question of who's actually being harmed in this. Increasingly, the debate's conducted on this basis and is being extended today from harm to individual patients to harm to the society at large. The next phase of the debate over assisted suicide will reflect the current discussion in Europe, which is focused on the demographic realities that Western cultures have to face in the coming decades. Advocates of assisted suicide, in my view, are increasingly pressing the demographic point in arguing for assisted suicide on the basis of gerontologist Joanne Lynn's statement that, quote, "there is nothing cheaper than dead." Now, bioethics, I think, further reflects Steve's statement that the neutrality to which the law pretends and aspires to is manifestly impossible. For example, I recall debating a scientist and physician a few years ago about the morality of embryonic stem cell research. One physician in the audience expressed exasperation about, quote, "you religious people imposing your morality on us." And since in sort of, I think, uncharacteristic of Dallas, I responded with a similar level of horseradish to which the objection came. I suggested that in response that we give up the silly notion that it's only religious people who are attempting to impose morality. That most, if not all law, in my view, and here sort of reflecting Brandeis again, is the imposition of someone's morality. Hence the presumed neutrality, and the myth of the presumed neutrality of the law. I would further suggest that bioethics is a good example of Steve's critique of public reason. That is, only secular reasons and purposes are allowed in the door of public discourse. And I think in bioethics in particular, those have been very effectively screened out when it comes to decision-making and policy-making, although they may be allowed in the door for deliberative purposes. Now, for example, in the congressional hearings and debate over human cloning some time ago, the NBAC's commission report included an entire section on religious and ethical views on human cloning, which included testimony from, every imaginable religious group under the sun. Yet in the conclusion to the report, when it came time to give recommendations, the commission put it like this. It said, Americans share some, but not all of their ethical and cultural traditions, and no single set of approaches that balances conflicting values in particular ways enjoys universal acceptance. Some theological analyses provide answers to their adherents, but these are incapable of serving as the sole basis for policymaking in a religiously diverse nation committed to separation of church and state. Hence, the screening mechanism was there at least stated explicitly for what it was. I think what's really meant here is that theological analyses, religious views are not even allowed in the door at all unless they are accompanied by some form of public reason. However we are defining that, I think that's still somewhat mysterious to me. Now, in business ethics, I think the disappearance of moral knowledge has taken on a little bit of a different turn than in bioethics. Here, ethics has either been subsumed by the law or become primarily procedural. That is, in saying so, I think we should recognize that in saying it's procedural, by definition, it is devoid of normative content. In the first instance, ethics and compliance in many areas of business ethics have become conflated. And I'm going to include here compliance not only with the law, but also with appropriate regulatory standards. I remember years ago when I was consulting on ethics for a large Catholic health system, I was asked to get involved not only with clinical ethics at the bedside, but also with organizational ethics in the boardroom. At the time, the system had a really significant compliance office and officer, which was really needed at the time because the laws, especially governing healthcare financing, were changing so quickly, and it was not hard to run afoul of the law without knowing that you were doing so. But the interesting part is that the compliance office was interestingly titled the Integrity Office. Maybe you can see where this was going. And the woman who headed it up was called the Chief Integrity Officer. And she didn't even have a sense of humor about it, unfortunately. One day, I just couldn't resist. One day in conversation, I asked her, I said, so tell me, what does the integrity office and officer do in this institution? And she shot back without missing a beat. My only job is to ensure that our managers and executives don't go to jail. And I couldn't help myself. And I said, I thought the bar for integrity was a little higher than that. In fact, I said, I'm not sure that ensuring our leaders are not indicted at the end of the year is an entirely worthy goal for an integrity office. But what was so clear was that compliance had completely overshadowed any discussion of what ethics was. And if I'd have been a little more courageous, I think she was about to bite my head off at that point. But I would have said, so tell me, how do you understand the difference between ethics and compliance? I'm not sure she would have had a good answer, and which I think is indicative of what has happened in the business arena with the disappearance of moral knowledge. Now, I think this is very common to see ethics and compliance as one and the same thing, with the result that, in my view, ethics has become reduced to the moral minimum. And that is that obeying the law is the moral floor and not the ceiling. So if not reduced to the minimum, then it is often reduced to the procedural, again, virtually devoid of normative content. This, in my view, is the way that ethics is taught in most business schools, particularly given the popularity of the case method for teaching in many of the disciplines of business. I think this is similar, Bob, to your point about how the case method has dominated the teaching of law as well. Now, the merits of this procedural approach are that they can be used in a variety of pluralistic settings with a variety of worldviews. I've actually used a model like this, very effectively, but have also chosen to smuggle in all sorts of things with it to actually make it work. The downside is that it's procedural only, has little, if any, content, and has even less in the way of inspiring or motivating moral behavior in the workplace. Now, just one other comment, I think, on the state of moral public discourse as it relates to morality. Steve, I think has maintained that moral knowledge has not exactly disappeared, but has been blocked or excluded from public discussion. The result is not amorality, but I think a generation that is intensely and harshly moralistic. And I think that observation is absolutely right. In fact, I would suggest that there's actually a new absolutism that is on the rise today. And the old notion that relativism is the order of the day, I think, is a somewhat quaint and outdated notion. As I read Dallas on this, I don't think he would disagree with that, since he points out that there are many ways in which morality is expressed and enforced today, often in very subtle but very significant ways. I think Steve is actually right. I think that public discourse screens out normative convictions or requires that they be translated into alien vocabularies. It seems to me the reason for this is one of moral epistemology. And this, I think, Greg, reflects back to your sort of category number 2 of what's meant by the disappearance of moral knowledge. That morality in general is not thought to be a domain of knowledge in the same way that other domains of knowledge are. I see this particularly, I find this even among my seminary students. I will ask them a series of questions, just very simple, about what constitutes objective and subjective statements. And I'll put a couple of moral statements in my list of the test cases. And usually if it's a contested moral case, like I'll say, for example, one of the examples I use is that abortion except to save the life of the mother is morally wrong. Objective or subjective statement. And there's a lot of consternation with people trying to decide whether that's an objective or subjective statement, which I think even among my seminary students I find was alarming. Now, to be fair, if I make it a moral case that's where there's no dispute, what's much clearer, then they're much more likely to say that that's a moral fact or a case of moral knowledge. But in the contested areas, we seem to go from knowledge, if it's contested, we go from knowledge to subjectivity. which I think is a dangerous trend and not a good sign for what's taking place in many of our churches. Now, I think when pressed, most people would agree, and this again I think is where Dallas is right for his particularism to appeal to the average person on the street. I think most people on the street would agree that morality is something considerably more than opinion, not precisely parallel to one's preference for flavors of ice cream or vacation destinations. I think just the notion that we happen to argue so passionately about moral matters suggests that it's something much different than that. Although I think I can't remember who made the point earlier in your paper, but it is, the public discourse on morality today has been reduced to either power or questioning of motives today, and I don't see there is as much space for rational argument, which is what sort of the idea of morality as knowledge presumes that we would have at our disposal. In fact, I think the failure to provide a, quote, science of ethics, I think has been well documented very recently by James Davidson Hunter in his book, Science and the Good. Now, I think the only note of optimism, I think, for a recovery of moral knowledge, I think, according to Stephen, I think he's right about this, is to unshackle religious communities and institutions to be themselves. And in doing so, enabling them to be the kind of lights to the culture at large that they were designed to be. It strikes me that this is strangely reminiscent of how the early church in the first century did this. Since the opportunity to have a public say in the first century was essentially off the table, the early church functioned to have influence on the culture in about the only way they could, given that setting, which was to form small, impactful, countercultural communities that acted somewhat like yeast and leaven throughout the culture as a whole. This idea of, and sort of mirror, this is I think to your point yesterday too, about encouraging the religious communities to be more explicitly who they are, especially when dealing with people who are intractably opposed to us. It's reminiscent. I had a very enlightening conversation with the Lutheran theologian Gill Mae Lander, who I suspect you may have known from your years at Valpo. Gill was reflecting on his service in President Bush's National Bioethics Commission, which he served during the entirety of the Bush administration. And Gill spent years of, quote, translating Christian ethics into publicly accessible terms on the council. And he finally admitted that in the last phase of his professional life, he was committing himself to being unabashedly Christian, regardless of the setting, and letting the impact chips fall where they would. Now, I heard this, for one, as sort of a weariness in the idea of translating Christian ethics into appropriate levels of public discourse. But I also heard this as I think, Bob, what you had suggested toward the end of your discussion, as an implicit trust in God for the impact on the culture, and underscored the importance of being who we are regardless of the setting that we are in. Now, just one final comment here, and I think, Steve, I think it takes a little bit further some of the statements you have made toward the end, some of the skepticism that you have had. And I think one of the persons who's influenced me significantly on this is James Davidson Hunter. In his book, The Death of Character, that Hunter's suggestion is short of a significant culture-wide religious revival, hopes for a renewal of character and morality, and I would suggest hopes for a renewal of moral knowledge in our time are not particularly bright. He states this really starkly in his book, in The Death of Character. He puts it like this, I quote, "We want a renewal of character in our day, but we don't really know what we're asking for. To have a renewal of character is to have a renewal of a creedal order that constrains, limits, binds, obligates, and compels. This price is simply too high for us to pay as a culture. We want character, but without unyielding conviction. We want strong morality, but without the emotional burden of guilt and shame. We want virtue, but without particular moral justifications that invariably offend. We want good without having to name evil. We want decency without the authority to insist on it. We want moral community without any limitations to personal freedom. In short, we want what we cannot possibly have on the terms we want it. It strikes me that the death of character and the disappearance of moral knowledge go together in some pretty significant ways, which I think lends urgency to our task and to a lot of our discussion about the recovery of moral knowledge.